Well, this is a super treat for me today because I get to talk to one of my favorite people in the world, Summer Ingram Dean at the Student Press Law Center. Summer is somebody that I've known since before she was an attorney, but now is a staff attorney with the SPLC, which is a nonprofit Washington, D.C. based organization that advocates for and provides services to student journalists and journalism advisors around the country. So she deals with a range of speech issues, access to information issues in the setting of schools and colleges where, as we're going to talk about, some legal twists and complications arise. So thank you so much for making time to have this conversation. And I guess just maybe start out a little bit by talking about, the practice of public interest law and what drew you to that and what a day or a week in the life looks like.
Sure. Well, thanks so much for having me, Frank. I have to say you are also one of my favorite people. You guys are so lucky to have Frank as a professor. He's been just such a wonderful force and influence in my life. So as far as how I came to sort of work at the SPLC, I was a student journalist in high school and in college. That's where I first heard about SPLC. I encountered some censorship issues when I was the editor-in-chief for my high school newspaper. And so that's when I first sort of learned about what the SPLC does, the wonderful people there who basically, we are here just to answer any sort of questions that student journalists or their advisors may have about any aspect of media law as it pertains to student journalists. And as you'll learn, student journalists face, the same issues that members of the commercial media face, plus more, because you have to deal with censorship issues, you deal with, covering your administration and covering the school community that you're a part of. And so, like I said, through college, I was a student journalist. And then in between college and law school, I worked for the Associated Press and for the Dallas Morning News, doing legislative reporting, doing reporting on higher education. And it was kind of in that time that I decided I wanted to go to law school. I was interested in just sort of learning more about how all this worked. I was interested in putting myself in a position to be able to help journalists sort of know their rights and fulfill the critical duty that reporters fill in our society. And so through law school, I sort of kept the interest in media law and journalism focus. After law school, I clerked for a federal judge, and then luckily my dream job was kind of open to me. That's working at SPLC. And so a day in the life, sort of as an attorney at SPLC, we often refer to ourselves as like the firefighters. So there are fires that are coming up. People are facing censorship issues. People are having problems getting access to public records that they are legally entitled access to. People have questions about, it may be a simple question like copyright law. Can I use this photo that I found on the internet to go with my article? Most of the time the answer is no. So things like that. We have a hotline where people can either set up phone calls with myself or someone else in our legal team, or they can fill out a form and we get back to them via email. And so it's really just a wide array of things that I deal with on a daily basis. Like I said, a lot of censorship issues, but also sort of helping student journalists figure out how to approach sort of sensitive stories. We have student journalists who are reporting on things as serious as, COVID outbreaks in their community, or Title IX stories on sexual assault, sexual harassment, and they're wanting to know, how can I publish the story without getting sued for libel? And so that will entail a lot of sort of working with the reporter on how they approach their reporting. Sometimes we will review articles before they are published just to give thoughts and let the student journalists know if we have any legal concerns about what they're going to publish. So yeah, it's really just a wide array of things. It's a lot of fun. I love that it sort of meshes the two loves that I have, journalism and the law. And so, yeah, no day is the same, which is something I really love about this job.
Yeah, I should give a shout out to the splc.org website for people who want to draw on those resources. And you know, for those of you who are maybe thinking about a career in the law, we're gonna over the course of this semester hear from a lot of people who are at law firms or are in media corporations. But don't forget that there is a career pathway in public interest law as well, working in the nonprofit sector where your client is not CNN or your client is not ABC News, but your client may be thousands of students around the country who you'll interact with, sometimes one phone call and sometimes for months at a time. And it's definitely life-changing and rewarding work. So let's talk a little bit about just kind of First Amendment basics, because the first thing that the students in this class will learn is about the workings of the First Amendment and how the normal rule is that the government can't discriminate based on content, can't discriminate based on viewpoint, can't punish you for anything short of a true threat of violence or something very close to it. How do those principles apply in the school setting? Do the same levels of First Amendment protection apply? And if not, where is that line drawn?
Yeah, I'd be happy to talk about that. So when you're talking about student voices, in a campus setting, the court case you'll always hear referred to as the Tinker case, and that's Tinker versus Des Moines. Um, I'll just sort of briefly talk about what that case entails, if that's okay. But basically, this was a case that arose back in the 60s. Mary Beth Tinker, who's the named plaintiff of the case, and a few of her friends decided to wear black armbands to school to protest the United States' continued involvement in the Vietnam War. So this was a pretty calm sort of thing. It's not like they were even marching through the hallways. They just wore these armbands, just sort of as a silent protest. They ended up being called to the principal's office and told to remove the armbands, which they did. Again, no sort of nothing, really chaotic happened. But the school still ended up suspending Mary Beth and a few of the other students. And so those students ended up suing the school district after the school board wouldn't overturn their punishment. The case made its way all the way up to the Supreme Court of the United States, which is, of course, the highest court in our country. And what the Supreme Court decided is that students don't, and this is probably, one of the more famous lines in that case, students don't shed their constitutional or First Amendment rights at the schoolhouse gate. So just because you're a student, at the high school or middle school level, if you're a minor, all those sorts of things, doesn't mean that you suddenly have no First Amendment rights. But the court said schools do have an interest in maintaining a certain sort of, educational atmosphere while you are in school and on their campus. So they created a test that basically says that before a school official, meaning a principal, advisor, anyone who works for the school, before they can censor student speech, they've got to prove that either the speech is unlawful, meaning speech that none of us have the right to partake in, whether we're students or not. So speech that is libelous, speech that is an infringement on copyright, speech that is going to incite sort of imminent lawless action, all those sorts of things. A school official has to prove that your speech either falls into one of those categories or that it's going to cause a material and substantial disruption to the school day. So that second category, material and substantial disruption, is what a lot of these cases are focused on. And so the courts have basically said in order to meet that standard, it has to be something that is going to be a physical disruption to the school day, meaning they can't just say, in the instance of Mary Beth Tinker and the armbands, they can't say, oh, some people may be offended by this, or they may, not like that they did this. It has to be something that's going to be really sort of dramatic and interrupt the school day, like cause students to walk out of class, cause fights on campus, things like that. And so that's sort of the standard that's been set for student speech, at least at the high school level. And I don't know if you want me to go on to sort of talk about how Hazelwood changed that.
Yeah, let's talk about that. So you've got this category of speech in schools that's governed by the Tinker Standard. And that starts out, as you explained, with armbands worn on your own person. But then the Supreme Court comes back in 1988 in the Hazelwood case, and they sort of move the line a little bit, right? Now there's going to be a new and different standard for the category of speech that's governed by Hazelwood. So, yeah, let's talk about that.
Yeah, so Hazelwood, one of our least favorite cases at SPLC, this was a case where the Supreme Court had the chance to talk about what kinds of censorship students or school officials could engage in when it comes to school-sponsored speech. So, um, speech that comes about as a result of students being a part of like a student publication. And in the Hazelwood case, students on the school newspaper decided to run a special sort of double spread issue where they talked about issues facing teenagers. So they talked about teenage pregnancy, they talked about divorce and how that affects students. And the principal sort of freaked out about it. He didn't argue that the speech was unlawful. He didn't argue that it would cause a material and substantial disruption to the school day. He just said, hey, these are really serious topics, and our students aren't mature enough to, talk about teen pregnancy or all these other things. So you can't run it in the paper. Um, so similarly, the students sued the school district. It made its way all the way up to the Supreme Court again, where many, I think, First Amendment advocates were probably thinking, hey, this has been decided before, they'll just apply, the justices will just apply the Tinker standard, and the students will win here. Well, the Supreme Court did something a little different. As Frank just said, they decided that in cases like Tinker, where it's sort of independent, private student speech, they decided that's a different category than when there is speech that takes place in, what they call the sort of school-sponsored manner. So the school newspaper obviously has the name of the school tied to it. It's it's overseen by a publications, like a journalism teacher that is paid by the school. All these factors that the court said could lead a reasonable person to believe that this was school-sponsored speech, that the school approved of whatever was said in this newspaper or, whatever other school publication it may be. So they said, we're going to create a different legal standard. Really ended up being a much lower bar for school officials to meet than in the Tinker case. So what the Supreme Court said is that before school officials can censor school-sponsored speech, all they have to prove is that basically that they have a reasonable educational justification for the censorship. It's a very vague sort of standard. And the examples that the court gave are things that really should kind of make you feel like, oh, that is really giving school officials a lot of power. So they said, if the school officials, if they say, oh, your grammar is bad in this story, you can't run it. That's going to be enough to be considered a reasonable educational justification. If the principal decides, oh, this doesn't comport with the, sort of ideals and values in our society, then they can say you can't run the story. Things that are really giving these administrators a lot of power. And yeah, so the Hazelwood standard is what is used, to this day for school-sponsored publications that have not been deemed public forums. And so without sort of overcomplicating what that means, a public forum just basically means if your school newspaper or magazine or yearbook or whatever it is has either in policy or by practice operated under the notion that the students themselves have sort of final say over content in the publication, they've been established as a public forum, and the Hazelwood standard wouldn't apply. So it's still, a pretty Hazelwood still gives, like I said, the school officials a lot of power. And this is at the high school level. But, I get a lot of calls from high school student journalists who say, hey, my advisor approved this article and said we could write about, whatever it may be, drug use, teenage pregnancy, even things like COVID that you would think, why would student journalists not be reporting on this? They said, my advisor said I can do this, but the principal is saying that we can't. And so Hazelwood often comes as, a pretty big sort of roadblock for students who are just trying to do, this very important work of reporting on what's happening in their communities. And so, Hazelwood is supposed to be sort of kept to the high school and middle school level. But there was a case, was it in the Seventh Circuit, Frank, that
Oh, the Hosty versus Carter, right? Seventh Circuit case. Yeah.
yeah, that sort of applied it to the college level. And so, um, anyways, all of that to say, we don't like Hazelwood. It's a problem.
Yeah. Well, and you mentioned this that even though in the Hazelwood case, it was really about articles where, at least according to the attorneys involved in the case representing the school, the concern was that it was very bad quality journalism, that it might have had things that were libelous or that invaded the privacy of families. And so they had all sorts of justification for withholding these stories. That as history has unfolded since that 1988 decision, that in fact it's not just used to suppress bad journalism, but is sometimes used to suppress good journalism because it's so open-ended and it's such an invitation to engage in viewpoint-based censorship of the kind that the First Amendment would otherwise never allow the government to do, right? Government can't discriminate based on viewpoint in any other context, but it's possible at least that the Hazelwood standard invites that, so that if a student writes an article, let's say, advocating for the rights of transgender kids, and the administration of the school decides, well, that's too mature of a topic for our audience to handle. I'm going to remove that article from the paper. Hazelwood gives them some legal cover to do that.
Yeah, exactly. So, it's a frustration that we face a lot, sort of in my job. And there are, I'll just talk briefly about the New Voices laws. There are some laws at state levels that we call them New Voices laws. Sometimes they're referred to as like student freedom of expression laws. But anyways, it's on a state by state level, and these laws basically seek to restore tinker levels of protection to student speech. And so in those states, I think there are about 14 or 15 of them. In those states, the Hazelwood standard isn't going to apply. And so that gives us some hope. Often one of the first things I ask when a student calls with a censorship issue is, what state are you calling from? Are you in a public or private school? And if they're in one of those, handful of states that has the New Voices laws, it's really great. It gives us something to work with. So, that's an effort that we're working at SPLC, sort of with different contingencies all across the country, to get passed in more states.
Yeah, I'm so glad you raised that, because that's such an important kind of like a civics 101 point that people don't often get in their civics class, and that I know I have to educate people about all the time, is when the Supreme Court speaks in a case like the Hazelwood case, they're just setting the floor of your constitutional rights. They're not setting the ceiling, so that when the Supreme Court says a school has the authority to censor up to this point, an individual school or a district or a state could decide to forsake that level of control. They could decide by statute, by rule, by regulation that, no, we won't take all of the authority that the Supreme Court said we could take. We'll draw the line in a different place. We'll locate it more closer to the tinker line, where an authority figure couldn't engage in censorship up to the point, unless they can show illegality or disruption, which would be a much more protective standard than what we have now with Hazelwood. So I'm glad you raised that. I'm also glad you mentioned the concept of a public forum, because that's something we will talk about in the class, this idea that your right to use government property as a vehicle for you to speak on depends on the nature and the status and the history and the usage of that property. This is something that comes up on college campuses all the time when people like the neo-Nazi Richard Spencer show up at your college campus or want to use an auditorium in order to be able to deliver their neo-Nazi hate speech. One of the first legal questions that will come up is, well, is that space a public forum? Is that space a place that has been dedicated to and set aside for members of the general public to engage in expression? And if it has, then a lot of First Amendment protections apply, and there's very little the government can do to stop you from speaking in that space, even if they intensely dislike what you're planning to say. So yeah, your use of government property, including that newspaper or yearbook or magazine, depends a lot on whether it qualifies as a forum or not. So yeah, that's an important point. Well, you mentioned two concepts I want to go back to. Concept number one, we should emphasize, right, that everything we said so far about the First Amendment is about public institutions, right?
Right. Yeah. So, like I said, one of the first questions I'll ask is what state are you calling from, or if you're at a public or a private school. And the reason that matters is because at a private school, students don't, well, I guess I should put it like this. School officials are not governed by the First Amendment, at all. The First Amendment only applies to state actors, government actors. And so at a private school, these people are privately employed. They don't answer to the First Amendment. They are not subject to those rules. And so at a private school, it's a lot harder when it comes to issues of censorship to sort of fight against that. Everything else at a private school is basically the same, the same standards for libel, for, getting access to records, all those things are the same. But when it comes to facing censorship from a school official, private school students aren't going to be able to rely on the First Amendment. So a lot of times what we try to do is help students basically sort of call attention to the censorship that's happening. A lot of times I think what these school officials fear is, looking bad, so to speak. They don't want, a certain story to run because they think it'll make the school look bad. Well, if you publicize the fact that, these student journalists are working hard to report newsworthy things within their community, and the big bad school is not letting them do it, well, that's going to make them look bad. So a lot of times it'll entail getting students to work with sometimes their local, like commercial news outlets, who will sometimes run the story for them if their school won't run it, who will report on the fact that, this censorship is happening. Sometimes SPLC will get involved and, just sort of elevate it to sort of a national level of attention. And then in a few cases, I think it's been found that certain promises that schools make, so like in the student handbook or, I don't know, like a code of conduct or something like that, where they, say this is, this is a place where we encourage student voices and, things like that, open dialogue. In some cases, courts have found that basically serves as sort of like a binding promise that the school has made to students, not to censor them. So it's pretty tricky when it comes to private schools, because it's not necessarily a straight, legal solution, but there are sort of other ways to maneuver around it. And some of the New Voices laws do include private schools within that level of tinker level protection. So that's always something that we love to see as well.
Yeah. So, and also you mentioned the uncertainty about press freedom at the college level. We really don't know conclusively whether the courts will apply that Hazelwood level of heavy administrative control to college journalism or not. You mentioned the Seventh Circuit in one case decided, yes, it looks to us like the Supreme Court said student and school, and you are students, and this is a school. And so the Hazelwood level of control applies at college as well. Other courts have not been so willing to go that far, but the Supreme Court has never said for sure. They haven't had a college journalism case yet. And so just talk a little bit about kind of what the press freedom climate looks like on college campuses. And if not press freedom and censorship, what is the thing that makes your phone ring when it's a college journalist and not a high school journalist?
I think that at the college level, what I see more of, rather than, sort of overt censorship, is budget cuts, is other sorts of methods of basically hampering student journalists from engaging in the kind of coverage they want to engage in. And so, yeah, I think at the college level, what makes our phone ring a lot is, I'll get a call from a student journalist that says, "Hey, we've been doing this coverage that student government really is the source of a lot of the issues at the college level." And so, they'll say, we've been writing these sort of critical stories of the school administration or of student government, and now student government is in charge of dispersing, student fees. And so many of those student fees are normally allocated to the student publications. And so they say, the student government is upset with us, and they're, slashing our proposed budget or the normal amount of funds we get by, some absurd amount. And so what can we do? And those issues are a little trickier, just because you have to sort of tie, budget cuts aren't in and of themselves sort of unlawful, obviously, but you have to tie, if you're able to tie the fact that the people in position to give you money are, offended by or upset by the coverage that you've done, if you can tie that to the budget cut and prove that it is content based, that's the key, and that basically makes it censorship. And so, I work with a lot of college journalists, and, making sure that they have sort of documented, anytime someone has said something negative or, threatened the future of the student newspaper or magazine or whatever it may be. So those are a lot of the calls that I get at the college level. Less sort of, this administrator said we can't run this story, and more sort of, well, they're finding ways to erode away, how they're able to cover these stories, and it's frustrating because it's easy for, student government or for school administrators to say, "Oh, well, we're cutting the budgets of, this, and this group as well. We're not singling you out." But a lot of times it's very clear that that is what they're doing. So yeah, I think that's a pretty big bulk of what I deal with at the college level.
Yeah, and so one of the concepts that we study in First Amendment law is this idea of the prior restraint, the idea that the government could step in and actually stop a publication from being distributed. And that's not so much of a concern at the college level as it is at the high school level, just because the means of distribution are often out of the direct hands of the administrators of the institution. So not so much prior restraint, but if there is a retaliatory cause and effect, as you've described, that the government takes away something that you would otherwise have received, but for the content of your speech, those are at least the building blocks for a potential First Amendment case. And it could be money, it could be being fired from a government job, it could be removed from an office that you otherwise had the use of, right? Something that concretely punishes you in a way that would chill your willingness to engage in speech in the future could be the makings of a First Amendment retaliation case. So yeah, no, it's important to keep in mind that there's lots of ways that government can infringe on your First Amendment rights. Yes, they could stop you from speaking, but after the fact, punishment also is effective in inhibiting people from speaking, sometimes has the same effect as stopping you in the first place.
Yeah, exactly.
So we should wrap up by talking a little bit about, even though this is not what the SPLC was founded to do, it was founded back in the 1970s, but I'm sure your phone rings, I'm sure you get emails from people, and you find yourself from time to time maybe taking part in court cases about social media, because now that's how people are distributing information. Um, what do we know, or what do we not know about the level of legal protection that a student would have when the controversy is not about the content of my newspaper or my yearbook or my magazine, but it's the content of my Instagram or my Twitter account?
Yeah, so you're right. We are getting more and more requests sort of about, not even just from student journalists who are, posting something on, like say your school newspaper has, an Instagram account. We're getting questions from just, sort of regular students who have posted something on, their TikTok or whatever it may be. And, they're being threatened by their school that if they don't take it down, they'll be suspended or something like that. So, the question of what power your school has to punish you for social media content is still, I guess the best way to put it is still much debated. It's still kind of open, and I think it's one thing that courts have made clear is that school officials' authority to punish you for speech outside of school is going to be much more limited than when you're in school. I mean, that's just sort of common sense. But our position at SPLC would be that school officials should have, pretty much no authority over your off-campus speech. There have been, a few cases that have sort of tested this. There was a recent case in the Third Circuit, I think, where a cheerleader, I think I'm getting this right. She was like on the JV squad of her cheerleading team and then found out she wouldn't make the varsity squad. So on Snapchat or TikTok or something like that, she posted a video or photo of herself and some friends basically flipping the bird, the middle finger, and, cussing out, everyone that had anything to do with the cheerleading decision. The school tried to punish her for that. She sued. And this case, again, it's only in the Third Circuit. It hasn't, I think they're trying to take it to the Supreme Court. I think so, but it hasn't.
Trying to get the court to take it, yeah.
Yeah, but it's not to the Supreme Court level yet. But anyway, so at the Third Circuit level, the court basically said you can't take sort of the tinker level of protection and apply it off campus. The court basically said, this is just not, this is Tinker and Hazelwood. Well, I think they only talked about Tinker, are meant for, sort of these on campus experiences, and it's not meant to be taken off campus where, you're sort of you're on your own time. It would be very hard to make an argument that something you posted on off campus is going to cause a material and substantial disruption to the school day on campus. It's not that it can't be done, but it's pretty unlikely. And so that was, I think, a pretty encouraging sort of opinion from the Third Circuit, and may give some guidance to other courts that are, grappling with this issue. I think one thing is clear is that, if you are going to be punished for off-campus speech, it does have to have some sort of bearing on what may happen, at school the next day or whenever it may be. It can't just be something that's totally unrelated at all. So it's still sort of an area that is changing, and that courts are still trying to figure out how to deal with, but definitely something we're getting more and more calls about at SPLC.
Yeah, I mean, one of the things that seems kind of categorically different about social media speech, as opposed to going back to the 60s and what the Tinker family did, is the Tinkers are wearing these iron bands on school grounds, in class, during the school day, in a way that can't be ignored by the people around them. Social media speech seems like, one could argue, it's categorically different. Social media speech is speech that you voluntarily encounter in your off-campus life, and you can navigate away. You can click away. If somebody is wearing something in the school that causes you distress, you're stuck looking at it for 6 hours, right? Whereas if it's on a TikTok, well, you might see it for 2 seconds, but you're certainly not going to see it all day long. And it's certainly not going to be, because nobody's supposed to be on TikTok in the middle of class, right? Not going to be in class in a way that it can cause an instantaneous disruptive reaction. And so one could argue that if somebody sees something at home on a TikTok on a Saturday and then chooses to bring that beef onto the school grounds on Monday by starting a fight, well, that's on that person, right? That's not on the speaker. And maybe the right route for the school is punish the person who decides to bring the beef onto the campus rather than the speaker. But that argument has been quite challenging as the barrier erodes between what is regarded as off campus and on campus. And I think smartphones have done more than anything else to erode that barrier. That it used to be that the school could control what you accessed on their computers. They could put filters, they could block certain websites from being accessible. But now that everybody is walking around with a data plan, it's harder and harder to say that it's not accessible on school grounds any longer.
Right. Yeah, definitely interesting questions. We'll have to see how it goes.
Yeah, well, I want to thank Summer Ingram Dean for sharing her expertise and her perspective with us. It's such a delight and a treat to get to talk to you, and do encourage people to check out splc.org and to think about that organization as a resource and maybe a place to work someday. So thanks again for sharing your time.
All right. Thanks, Frank.